is that we do not doubt the immense powers that you have as a court, powers donated to you by law, Your Honor, there has been mentions by my learned colleagues for the prosecution making reference to a particular precedent that has been previously made, over and above the reference to the Constitution. Your Honor, I submit with humility that it is important that when we are making submissions that involve the application of the Constitution, particularly the question whether there is enough ground to continue with the detention of the respondent, it is paramount, Your Honor, that the court also reflects on a book written by Ronald Dworkin, Taking Rights Seriously. Your Honor, your ruling of the 2nd day of May 2023 essentially limited the freedom of movement of the respondent. You gave the applicant an opportunity of utilizing the evidence that they had already collected to take any adverse or whatever action that is there against the respondent. Or looked at it differently. You gave them the opportunity of going to look for that adverse information or evidence that they can use, so that today, Your Honor, we can have at least a closure of the file that we have before you and the commencement of what will be criminal proceedings as against you. Your Honor, we are lucky that our client is a revered scholar of the Bible. And there is much that is said about the 10 talents. Your Honor, having granted the respondents 7 days, taking into consideration the affidavit that was sworn by the investigator on the 28th day of April 2023, an affidavit that makes very wild accusations, painting a man of God into those colors. Your Honor, the opportunity that you had given to them has not been fully utilized. And yet, they brazenly approach you, Your Honor, now not asking for 1 or 2 or 3 days, but 30 days, Your Honor. Your Honor, your point of call must be an interrogation of the precedent that was set by Justice Professor Joel Ngugi.
The Sudi case.
Yes, the Oscar Sudi case, Your Honor. And with humility, Your Honor, I will remind the court of the double test that my learned judge then set to be used by all. Your Honor, the first limb of that test, which the court, I am very confident, I am very confident the court has interrogated these issues even before. The question of good faith and exceptional circumstances. Your Honor.
The case of Oscar Sudia,
Yes.
I'm quite familiar with that decision.
Thank you.
So you don't have to go deep into it.
Yes.
Unless there is a particular issue you must highlight.
Yes.
Yes, I well know that decision.
Yes, Your Honor, I make reference to the double test, especially likening it to the facts that
I even have the history.
Yes.
Including the history.
Yes.
I even know the magistrate that handled it.
Yes.
Up to the time it ended up before Professor Lugia.
Indeed, Your Honor. Your Honor, it is important that even before the court can even consider entertaining the application that is made by counsels for the prosecution, to interrogate the facts. My senior, Mr. Magolo, made a very good, at least analogy or submission with regards to circumstances before and now. And what the court might take judicial notice of is that the man who has been likened or associated with the respondent, one Mr. Paul McKenzie, after his arrest, his house was torched. That is an important circumstance that happened post his arrest. The court might want to ask what became of the respondent after his arrest and detention. Your Honor, his followers have been flocking the court compound. The court every morning has been treated to religious songs and dance. Your Honor, that does not speak of circumstances that will warrant the continual detention of the respondent. In any event, Your Honor, I'm not shy to submit that the prevailing circumstances, Your Honor.
I'll give you 2 more minutes.
Thank you. The prevailing circumstances, Your Honor, point to a man that is deserving of an order of discharge, or at the very least, release on some reasonable bail or bond terms. Your Honor, in closing, I must mention, Your Honor, we are living in a new constitutional dispensation.
13 years later.
Yes, 13 years later. Yeah. And I am sorry and I regret, Your Honor.
And I hope you are not one of those who refers to it as the new constitution. It is 13 years old.
Yes, yes, yes. We have had the misfortune of people living with hangovers of the previous constitutional regime. A regime that did not even entertain the thought of a person accused of murder being released on bail. So that, Your Honor, looking at the current constitutional dispensation, we should not even be astonished or surprised by any arrangements or efforts being made by the state suggesting that they will plan to charge him for murder or for whatever offense that is there under law. Because in the name of the Kenyan Constitution, all persons, regardless of the offense they are charged with, have a constitutional entitlement.
Your time is up. Wind up.
Of bail. And Your Honor, I close by urging the court with humility, Your Honor, consider setting this innocent man free and give them the enough time that they require to complete the investigations. Nothing will change even after the investigations have concluded. Thank you, Your Honor.
Any rejoinder by the states?
Yes, Your Honor.
Yes, Mr. Musyoka.
Yes.
Yes.
Your Honor, of interest is the application that was initially brought before you. Just to point out, it was brought under court. In such manner, we sought for time. We again come to you to seek for more time. You know, the court found it fit to grant us time in the first instance on reasons that were well canvassed. Today, Your Honor, we've stated clear, indeed, there is change of circumstances. There are new emerging issues that if time is not allowed to the investigators, you know, we will not achieve justice for the man before you, for the victims. You know, we're not talking of 2 people. We are talking of 100 plus.
Your Honor, the state is such a protest that knows we are only to respond on questions of law. I wouldn't want to teach anybody that. Purely a rejoinder of questions of law.
He has a right to respond to issues of law and any other issues that came up during the response.
Thank you for the question.
Any issues that you brought up during the response, they have a right to respond to them. Any new issue that came up during the responses.
Thank you, Your Honor, for that guidance. And that is the reason why, extensively, the defense used certain words, which when I found them very entertaining to the crowd, to say persecution and again to say prosecution. You know, there is nothing in law, as we have appeared before, that we can say we are persecuting anyone. It is in the interest of everyone, including the state and the defense, to allow the prosecution, together with the investigators, to come up with any evidence that could be useful to the victims, to the respondent. If there is none, we wouldn't be here. You know, we say so because at great length in paragraph in paragraph 14, we stated that the respondent is a man who has a following. And the following, Your Honor, is not a small following. Your Honor, we are speaking of 45,000 known persons to the respondent, not to the prosecution, not to the investigators. Your Honor, if a man, a single man, has that following, there is nothing more we can speak to explain what influence means. You want to bring you closer home. The defense was courageous enough to tell us outside here, within your premises, the court premises, people are there.
I want to discuss conception if it's
That's strange.
I wasn't there, but whatever they told is honest.
But I haven't even heard, Mr. Magolo, Mr. Omari, I've not even heard what you're objecting to.
No, he just started
Because I do not know what he's about to say.
What he started to say,
Yes.
the way he said it,
Yes.
But I was told outside here, within the premises of the court, clearly whatever he was told, it does not need to go beyond that.
When I said it was said by the defense,
Yes.
counsel said that the following, there are people singing and playing outside.
Okay.
That is my submission. And if you're not, if that's
Mr. Wamboy actually, was it? Actually saying that. Yes. Proceed.
And therefore, Your Honor, that is the same thing, Your Honor. The defense has been saying that prosecution has seen that we are not the winning side. Your Honor, this is not about winning. There is nothing about winning here. It's all about justice. And if one man, Your Honor, can appear before you, followed by a crowd of other people, and it is admitted from the bar that they are outside, what else are we asking about influence if they are not?
The question Mr. Omari was posing,
Yes.
now that he's in custody, how then does that influence when?
I'll come to that.
Yeah.
At least I'm responding to what Dance was saying, that this man cannot influence. Yes. Secondly, Your Honor,
With some respect, can you call me pastor? Please, with some respect. Kind.
You may refer to him as the respondent.
All the rest of it.
Yes.
Kind.
I have continuously referred him as the respondent. And on a light note, Your Honor, the Bible calls everyone man.
Proceed. Proceed, and you have 2 more minutes.
Which Bible?
Your Honor, continuously, the defense, in their wisdom, they chose to invite you to look at Article 3 of the Constitution and disregarded Article 49(1)(g). That is why we are here. Both articles, Your Honor, must be read together for us to be able to interpret the reason why we are here. And the reason why we are here, Your Honor, is simple. To explain to the respondent why we need him in custody and why we intend to have him continuously to remain in custody. That is found in Article 49(1)(g). We have expressed that clearly. If you look at Article 1(b) or quarter.
Section.
Yes, sorry, section 33, 1(b) section. It speaks of the manner in which we can approach the court. You know, we've chosen the known and laid out procedures. That is where the procedure is.
The section talks about an application served upon the respondent.
Yes.
This was an oral one.
And
The one today is an oral
Yes.
one. Yes.
And the court in the previous one today stated that the prosecution may move orally.
Yes, yes. You do not expect that I knew
Yes.
your application before you made it.
Very well.
Yes.
Well guided. And therefore, Your Honor, we are well guided by that particular section to state that indeed, as we appear before you, we have complied with all known provisions of the law.
Yes.
And therefore, Your Honor, it is only in the, if any, because, Your Honor, there are emerging issues which have been laid out in the affidavit, and those issues are speaking of post-mortem. The defense stated that, Your Honor, there is nothing new about post-mortem results.
Your time is up, wind up.
Your Honor, post-mortem results are very crucial. They are linking us to the cause of death. We intend to have a DNA carried out. That is DNA exercise carried out as soon as possible. It is only fair that this respondent or the respondent who is a peace-loving Kenyan as the state and a man of God as the state, which we respect, that he doesn't influence the rest, the family members who are relatives, since it is clear that the victims are also followers in his church.
Where do you get that? That the victims of Shakahola are also followers of his church?
I did not say Shakahola.
Which victims are you talking about? Listen, please take your seat. Court decorum, I'm addressing counsel, Mr. Musioka. I'm wondering which victims are you talking about? Be clear about that.
Yes, we are speaking of victims of the deceased as persons. That is the relatives of the deceased persons. And for that exercise, which is a DNA exercise to be carried out, we must have family relatives. That to be carried out, they must avail themselves, and that is our submission. I end it at that, Your Honor.
Yes, Your Honor. Just very few minutes to sum up what Mr. Achiwe said. You know, one thing that a lot of people do not understand is that prosecutors, by their very job, are ministers of justice. So the issue of persecution, as alleged by counsel, should not arise. Even as prosecutors, from where we see, we seek to establish the truth. But that is
I do not think anyone has talked about these prosecutors before the court persecuting the respondents. Rather, I think what they were alluding to is the state persecuting, that is the word, the respondents, not your office.
Yes. Thank you for that clarification, Your Honor.
At least that was my understanding.
Yes. That I believe if you put it that way, then we would.
I can assure you that that is the way I understood it.
Okay.
Yeah, so let's proceed.
The most important thing, Your Honor, is how you understood it, and we are glad you understood it. So what our submission here, Your Honor, there is one fundamental question that is being asked: that why do we need another day? That in our affidavit we have not given the reason why. We did not have an opportunity to state what is in our affidavit because the court already has that written affidavit. Yeah. The defense has that written affidavit. But for purposes of clarity and record, this is why we request for those extra days. We are saying that when we appeared before you, speaks about compelling reasons as a result of the change of circumstances. And when counsel submitted and said that there are no compelling reasons, our response is these compelling reasons are as a result of the change of circumstances.
What I was worried about is when you say that we are past that stage of compelling reasons.
No, okay. I will rephrase. The compelling reasons are as a result of the change of circumstances. That is what should be read. So based on this change of circumstances, we then now submit that this change of circumstances has resulted into the state requesting time for more days in order for these victims who are supposed to be profiled with the bodies that suffered death by strangulation and beating by blunt object to be matched. Which again led to us saying may result to the charge of murder. We are not saying we are preparing murder charges, and that has to come out very clearly. We are not saying we are preparing murder charges. We are saying it could be one of the charges that could be prepared. And in any event, this court can entertain an application for custodial orders even if it relates to the case of murder. It cannot only try the case of murder, but it can extend custodial leave even in charges that relates to murder. I beg to see.